All right, I hereby call this meeting back into order. This is the other matters agenda for the Code Enforcement Special Magistrate. The cases will be heard in the order in which they appear on the agenda. If you hear your case called, please go ahead and proceed to the podium on my right-hand side. This is not a formal courtroom, so the formal rules of evidence do not apply. However, all testimony is taken under oath under penalty of perjury. So if you're going to testify today, or you think you might testify, or there's a possibility that you might testify, would you please rise and raise your right hand? Anyone that's going to speak? Do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury under the laws of the state of Florida? I do. Please be seated. The city can call their first case.
Number 1510 Independence Road, CE 14030533. Number 1510 Independence Road.
Go ahead.
Mitch Posner, Code Enforcement, case ending in 533, 510 Independence Road. Date ordered 5/21 of 14, fine started 6/21 of 14, ran for 1,910 days. Total is 95,500. Daily fine of $50 a day, date of compliance 9/13 of 19. This is a new owner. The case was for work without permits. According to our records, it was apparently rented without a license until April of 2021. The only mitigating circumstance on the application that they gave was they complied the violation. Of course, they wouldn't be here without that. Normally a 30% ask based on the amount. We're reducing our ask to 20%.
Sir, can you tell me your name, please?
Mordecai Barzani.
Mr. Barzani,
Yes.
can you tell me what you're asking me for and why I should grant it to you?
I'm asking you to reduce for me this lien for zero because I comply with all the permits that was necessary over there, and I got the place without me knowing that I have the 90,000 lien. And when I did all the permits as needed, they told me they're going to reduce it for me, and don't worry about it. If you comply with everything, you're not going to have to pay the fine. So I complied.
Who said that?
Mr. Brown.
Do you know anything about that?
It was
I
verbally.
do. I've asked Mr. Brown about this, and what they said was they were not going to charge. Okay, in the case of work without permits, when you go get the permitting, they can charge up to 4 times the regular amount for having done it ahead of time without getting the permit. They generally waive that if the work was done before you were the owner of the property. And that's what Robert Brown was talking about. They weren't going to charge more for the permitting since somebody else had actually done that prior to him being there.
So the city has offered to reduce it by 80%, which would be how much? Calculator here.
19,100.
So the city has offered to reduce it from 95,000 to 19,100, is that it?
You said it's 10%, not 20. First of all,
I'm sorry?
you said 10%. The lien is,
I didn't make any offer at all.
no. He said that the city is offering 10% to reduce it to 10%.
I said 20%. I said normally it's 30. Because of the high amount, we're reducing the ask to 20%.
You're going to have to give me something. The city's offer seems not unreasonable under light of the circumstances. Why should I do anything further?
I understand. if may I say that I took all this money to buy this place and repair this place, I took it by loans. So now that I complied with everything, Mr. Brown told me, I know that you didn't do these problems, but you're gonna have to fix them. If you're gonna fix them the right way, which is with the bringing to the city all the proper drawing and everything will go through, we're gonna help you to reduce it to zero. And then I didn't know that it's necessary to do a rental license, which I went and did. And Miss Monica Williams told me that don't worry, everything will be okay. We're gonna try to help you as much as we can. So I did comply with everything, and I really don't have money to give to pay this. Even
So the original, hold on one sec. The original violation that we're here on was the conversion of a garage to a living space, is that it?
Yes, sir.
And that eventually was properly permitted?
That was not properly permitted, but it was the previous owner who was cited. He purchased the property with the fine already running for that case. What Robert Brown did, realizing he's a new owner and didn't cause this, was reduce the amount of the permit costs. He wouldn't have the authority to say, we're not going to fine you or anything like that. That's the magistrate that does that.
How did he bring 105.1 into compliance?
He did get the permitting. He just paid he didn't pay any overage on the permitting costs. He got the permitting, he got the work inspected, they passed inspection on the permits, and that complied the case.
And how quickly did it take him to do that? Did he do it, how soon after?
Purchase May of 19, complied September of 19, so it looks like 4 months.
How would you assess the gravity of this violation?
At the time it was cited, I would say that's of high concern, because you're talking about converting something to a living space without it being inspected for any life safety hazards and then renting it out.
Are there any prior or subsequent code violations on this property during the current owner's time of ownership?
No, sir. No, there's no significant history with this particular owner at all.
And no other properties in the city that this owner has been cited on? That you're aware
Not that
of?
we're aware of. We haven't found anything like that. The only issue we found, as I stated, was he was renting without a license through April of 2021, which has been rectified to get to the hearing. But it wasn't cited. It was found during the lien reduction process.
Sir, do you have any factors that show a hardship on behalf?
I'm sorry?
Do you have any factors that may show a hardship on your
What do you mean by hardship? I'm sorry.
difficulties that you're having that may give me a reasonable basis for your requested relief? In other words,
Yes, now I have a difficulty to do insurance because before I didn't have this property and the insurance company does not want to give me insurance. So I have difficulty everywhere.
all right, I'll tell you what I'm willing to do. I'll reduce it
I'll
I'll reduce it to 10%, which is $9,550, payable within 60 days.
Sir, I need a really more help because I really complied with everything and I didn't create this problem.
Yeah, I appreciate that, but you have to also understand that if to get out of a code lien, all you have to do is convince somebody else to buy your property, then the code liens mean nothing, right? So, I mean, the city offered 20, I'm offering 10%.
I'm not trying to sell it. I'm trying to have income when I get retired. Do you understand? That's why I bought this property and everything by.
Well, what do you believe would be reasonable?
I believe will be reasonable 5%, $4,500. Even this I can't, but I'm gonna do that.
I'll do 7,500, payable within 90 days.
Magistrate, can we extend that time? I want to make sure he gets every chance to get that paid.
How much time do you need?
I need at least like half a year. Can I pay it in payments?
Well, I don't know, that's up to the city, but I'll give you the half a year, 180 days.
Thank you.
Is anyone here for 3028 Robert Road? Skip that. Number 4, 716 7th Street, CE 15120451. This property owner's here for a different property as well. I imagine you want to hear them separately.
It's the same owner, same situation on both properties, if we can hear them together.
We can do them one after another. Are they here?
716 7th, 820 43rd. Nicholas?
Well, let's go to the next one.
What happened to Robert Road?
Number 5, 719 21st Street, CE 07010785.
Which one was that? I'm sorry.
Number 5, 719 21st Street.
Okay. 719 21st Street, case ending in 785, date ordered 4/20 of '07, fine started 8/21 of '07. Sorry, I wasn't sure if anyone was asking something, or...
No, you're on.
Ran
Go
for
ahead.
4,965 days. Total is $496,500. It was $100 a day. Date of compliance 3/25/21. This is the same owner. Under their ownership, there's been 16 cases, so this property's been partially city managed. There's also a second lien from the same case. It was a split order.
Thank you.
That one ordered the same date. That one started 5/22 of '07, ran for 5,107 days. That total is $510,700. $100 a day. Date of compliance for that one was 5/15 of '21. Correction on the amount because there was a partial payment in 2018. The full amount is $495,537.75. I believe they have that corrected amount on your other matters agenda, Magistrate. The mitigating circumstances is not received, but according to our records, they were well aware of the violation at the time. Normally, this is a 50% ask, but certainly based on that amount, we can't. The city's ask is 5% for both.
So there's a total of almost $1 million on this property?
Yes, sir.
So tell me what's going on here.
I think the
Excuse me, sir, could you please state your name for the
my name's
record?
Gary Wilson. Okay. I believe the initial code violation was dated sometime 2007 or something.
Yes, sir.
Okay. They sent the notice of the violation to an address in Lake Park, so I never got it. My position would be that it wouldn't make any sense to pay like the taxes on the property all those years, and for the amount to graduate over all those years with me paying the taxes if I knew about it. My legal address is 1467 8th Street. I never got the notice there, so I didn't know. That's why it happened. In the interim, all the violations that have taken place, the trash can in front of the house, storm shutters on the windows, resodding. I've tried to address all of those things, and I have. The last time the investigator came out, she took pictures. I corrected all those things at some cost to me. So the violation that goes back all those years, I never got it.
Can I address that, Magistrate?
Yep.
I'd like to correct part of that. Notice was checked and it was sent to the address listed with Papa at the time. I don't have that with me. What I do have with me is the magistrate's order from the hearing in 2007, signed by the magistrate, Brandenburg, and the same clerk we have here, Erica Nichols at the time, indicating that Gary Wilson, the owner, was at the hearing. So we definitely dispute any argument whatsoever that he was unaware of this case.
I was never at a hearing. This is the thing.
It appears you were at the hearing.
I was never at the hearing. I was never there. No, I said that. That's not true. That's not true.
Well, either way, as a question of law, the notice was sent to the address on Papa, so that would be sufficient. The city has just presented me with an affidavit saying, signed by the magistrate at the time, saying that Gary Wilson appeared on, yeah, this was 14 years ago, so maybe you forgot, but they don't make these things up. There's no reason to.
I don't know what happened, sir. I guess I'm on the old, I was never at a hearing about this house. My question would be,
I can't hear that, Magistrate.
You
Can
have
get
to
him?
speak into the mic. or no
I'm
one can
sorry. My question would be, why would I continue to pay property taxes knowing that all this money is accruing? That doesn't make any sense to me. I was never at this hearing. I don't know who was there, but I was never there. And since I've been notified of violations, all the violations I've been notified of since have come to my address where I live now, and I've lived for 20-some years, and I've taken care of all of them. I was never at this hearing.
So what are you asking me here for, sir?
I beg your pardon?
What is it that you're asking me for here? You called this hearing, so what is it that you're asking me for?
I'm asking that consideration be given for the code violations that have happened in the last year or two. I've taken care of them as best I could. I've been in and out of the hospital 5 times with this virus thing. So I'm asking that administrative costs, I'll pay it. I only have Social Security. This is my son. He's said, Dad, I'll help you with whatever it is, but 4, 5, 200,000, it's not even worth that. The property's not even worth that, and the neighborhood is going to crap.
It's like $1 million on this property?
They both ran for an average of 5,000 days combined. It's certainly, based on just the appraisal of the property, we can't maintain a $1 million lien, but that's one of the reasons we would reduce it to 5% of the total lien. According to our research, it's also currently selling for $90,000. Something else for you to consider, Magistrate.
There was an offer, and when it happened, they backed out.
How much is 5%?
Okay, on the $496,000 lien, it's $24,825. On the $495 and change lien, it is $24,776.89.
So that would put him at what, about 48,000, 49,000?
Yes, sir.
Sir, can you make me an offer more than the administrative cost? Because the city doesn't calculate that, so that's a vague number that doesn't mean anything to me.
I didn't understand what he says,
You didn't understand what I said or what he said?
what either one of you said in terms of what you're asking.
The city is offering to reduce it by 95%, which comes out to 5% per property, which comes out to about $49,000. That's the offer from the city. So far, you've told me administrative costs, but the city doesn't calculate those for me, so that's a
Okay.
number that has no meaning to me. So you have to give me a number.
So in order to make this a win-win for everybody, I need,
I'm pretty sure it's not going to be a win-win anyway. But yeah, you have to give me a number so I can at least think about what you're asking.
let me consult with my son to see how much money he has, because I don't have any. It's my son's wife, help me.
Hello,
How many
hi,
do you have?
how are you? My
Ma'am,
name
if you're going to
is,
speak, you have to tell me your name.
yes, my name is Lysandra Wilson, his daughter-in-law. And I'm just sitting in here and everything that is going on. So I just wanted, since.
Ms. Wilson, were you sworn in?
Yes, I sworn in the back.
All right, go ahead, ma'am.
So I just wanted to ask a couple of questions because I understand what is taking place and we are going back and forth whether this was acknowledged or not. But I just want to state the facts that when he did find out about the actual lien against him, that he did do everything that he could to take care of on a fixed income. The reason why the buyers backed out is because, like you said, the property is not worth what they're asking. And even if he was to sell the property, if they gave him $90,000, it still wouldn't be enough to clear a $50,000 lien. So therefore, once again, he's on Social Security. If he sold the property and got any type of money, they're going to kick him off Social Security. So we're talking about a lose situation for him. He's on a fixed income. He does not work. He's doing the best he can. He hasn't lived at the property. It was grandfathered to him, so he's kind of taking over ownership or whatever's there. But I just want to say that if we could, like he said, just come up with a number of $4,000 to just take care of some of the things. He spent over $8,000 just trying to get it together. I mean, and we know because he borrowed money from us. But the whole thing is that even though the city is trying to put a lien against him, he's taking care of the things. If he does sell it, he's still not going to come out on top because of all the money that he owes. Once again, he's on a fixed income. So $40,000, $50,000, even paying $5,000 is a lot of money.
And we just found out about this last year during COVID.
Right. And he has been in the hospital in and out, so he hasn't been able to do anything. We have documentation showing that he's had COVID and been hospitalized 3 different times. 4. I'm sorry, 4, 3 that I know of. So it's not that we're not trying to make payments or not trying to help or get the property taken care of. He's taken care of the property. He's done what he's been asked. But realistically, it won't be a $40,000, $50,000. Even if he sold the house, he still couldn't pay that.
Any such thing as a mercy, don't let yourself on the mercy of the court?
This is the mercy of the court right now.
Well, I'm not a court, but I appreciate the sentiment. Is city movable on your number, or are you pretty firm with your number?
I can reduce it maybe 1% more. The problem is 95% is already a large reduction. We factored in the things we normally would, but we're also dealing with an owner-caused violation and a history of 16 cases on the property. Yes, the other 15 were complied, but it still involved a lot of city involvement in those cases, which is always a factor in a lien reduction ask. We have to take into account all the other lien reduction cases today and in the future when we do these asks. I don't dispute anything they said regarding the finances. Per city code, that is something I know you have to consider. So, I mean, whatever the magistrate decides, wisdom of the magistrate, sir.
Excuse me, sir.
Yes,
I
go
just
ahead.
want to say, I'm Marcus Wilson. We're not trying to get anybody else to do anything else. Only thing we're saying is, since we've got the document, since we've gotten the information, we've jumped on it, we've took care of it. Being that this was sent to an address that is not on his driver's license, he's been in 1467 since I was in school. So being that this was sent to an address that is long ago,
Well, with respect, sir, the question about where the city sends it, that's just a matter of law. The city will send their notice to whichever address is listed as the mailing address in the property appraiser's records. So that's where they send it. So if it went to the wrong place, it's because the
But
because the property appraiser.
I'm not arguing where, all I'm saying is, being that we never received it, we couldn't take action on it. But since we've actually gotten this in our hands, whatever they said need to be done, we made sure we complied. And has not been feasible for him, but because they said to do it, we had to make sure that it was complied. All I'm saying is, had we had this in 2007, we wouldn't be sitting here right now. We would have did that then. We would have complied. So all we're asking for is mercy to say that, listen,
Well,
this
I
is
mean,
from
in fairness, the city has actually shown a fair amount of mercy here, which is, a 95% reduction per case. I know that's still a substantial sum of money. That still comes out to about almost $50,000 on a property that, best case scenario is worth about $90,000. I appreciate that that's high. What offer would you make to the city? I'm going to play mediator here for a second.
Once again, with everything being considered and listening to what you're saying, we're grateful that they, took it and reduced it by 5% or 95%, should I say. But we're talking about a property that won't make money, won't be turned around, not listed in a good neighborhood, or either listed in feasible cost right now, even if he did sell it, which is my point I'm trying to make. Once again, he's on a fixed income. He would have to come up with that number, but I'm thinking about maybe $4,000 to take care of whatever, paperwork, administrative fees, anything that it took to file these actual liens. Once again, the house is still there. It hasn't caused any harm to anyone, to any human form. It hasn't interrupted any kind of business flow or anything that's coming in or out of that neighborhood. So he has not committed any kind of thing that will harm anybody that's been around. It's things that happen over wear and tear of a property that was grandfathered to him. If this was a property that was located somewhere else where he can sell and pay off a bigger debt, absolutely, we wouldn't have a problem with that. But this property's been grandfathered. It's really old. Even the money that we put into it, he's not going to get that back. Has nothing to do with the city. I'm just saying that even if we did try to do something about it and pay a greater amount, it would not be feasible.
All right, I'll tell you what I'm willing to do. I'll reduce each case to $7,500, payable within 6 months. That'll give you time, if you really are trying to sell it, to try and sell it, and maybe pay it off that way.
Is that $15,000?
That's $15,000.
Okay. Is there anything else that we can do? Because once again, even with $15,000, he's on a fixed income. I don't see that happening over.
What I
6
can do
months.
is I'll give you an extended period of time to pay it. That way, if, it sounds like you're trying to sell the property, that way it'll give you time to try and sell the property, and maybe you could pay it off in the transaction.
We wouldn't be able to sell a property for a year only because they would not buy that property with a lien on it. That means that we would have to pay that money up front.
Yes, can I walk out here knowing I owe you $15,000, sell a house and then pay you?
But that's how it goes anyway. But what I'm stating
I
is
don't-
that he wouldn't be
I
able
don't
to
handle-
sell that
I mean,
house with a lien of
I mean,
$15,000.
Yeah, well, I'm not a real estate lawyer, and I'm not going to try and pretend to be one.
I'm almost one, but that's what I'm stating.
But typically, if it's an amount like that, you have $1 million on the property, so I can understand why somebody would walk away. $15,000 can usually be handled by an escrow, but I'd recommend that you talk to an attorney about that when you sell the property. But that's what I'll do. I'll set it for 180 days to give you time.
Can we make it a year? That's usually the outside
All
window.
right, we'll make it for, 12 months. That'll give you plenty of time to figure out how to do it, okay?
Okay.
All right, so in the two cases, CE 070178, this might be the largest reduction since I've been here, but we're going to reduce these to $7,500 each, payable in 12 months.
Back to number 4, 716 7th Street, CE 15120451. You're also here for number 7, 820 43rd Street, CE 16080457.
Case ending in 451-716 7th Street, date order 2/3 of 16, fine started 4/4 of 16, ran for 625 days. Total $62,500, $100 a day, date of compliance 12/20 of 17. Same owner. Case ending in 457-820 43rd Street, date ordered 9/21 of 16, fine started 10/24 of 16, ran for 266 days, total $26,600, $100 a day, date of compliance 7/17 of 17, also the same owner. And the city's asking for 50% in both cases. Magistrate, we've been dealing with this property, since 2016, but more importantly, back and forth since, without citing it, since 2017, because they've been trying since then to get to a lien reduction. For the first property, this is the 4th application. For the second property, it's the 5th application, and they haven't been able to get past the inspections till this point. Now, I do understand part of that wasn't, the owner doesn't live here, and part of that really was the people he was relying on, but ultimately, that's the owner's responsibility.
Which numbers are these?
Erica,
The case
4 and
num-
7?
4 and 7. Okay.
thank you. So, yeah, city's asking for 50% on both of those.
Sorry, can you tell me your names, please?
Ninoska Versalovic. Ninoska Versalovic.
Oh, I'm going to have trouble with that.
Nina.
Nina, okay. And you, sir?
Nicolas Versalovic.
Okay.
My brother.
And you represent Ito Enterprises?
Yes. Yes, that's my corporation, right?
Okay. So tell me what you're asking me for.
Okay. Like the gentleman said, at this property on 7th Street a few years ago was the code for the city. Everything has changed. It became a historical area. So when it became a historical area, that whole area, they required us to do a lot of work on the property to make it look really good, because they're trying to improve that whole area and that whole neighborhood, the city of Palm Beach, of West Palm Beach. So like he said, yes, we had Total Property Management, the company that was managing the house, right? So these people, whatever work they did, if they fixed it, they never called the city or the inspectors to come and to review to get the violations out. So all these things have been happening through this time, all these years, as he knows, and my brother has been helping me because I'm not very good at all this. So he's been talking to the gentleman, to everybody in the city, trying to get it all right. He just took leave of absence for 5 weeks from work to come and help me out, because every time the work that was done in these 2 houses, especially if the Total Property Management called the inspectors, he couldn't even pass the inspections. So we've been putting money to fix, and no results at all. So until now, I said to him, please, you have to do the work yourself. You have to come, sit here, hire people, you do it, you fix. He did all that. We put into that house more than $30,000. All the siding needed to be changed, different things, a lot of work. And finally, I believe you guys are satisfied with the work, right? Or is it good, the work that was done now?
Yes, or we wouldn't be here
You wouldn't
today.
be here if you weren't in compliance.
Right, but finally, and he knows how much trouble we had with all of this. And am I just talking about the 7th Street property or also the other one?
Both.
Both? Okay. And the other property, okay, when we tried to sell it a few years ago, we didn't even know there was this lien on the property, okay? So this lien was from something that happened with the previous owner, and they came in front of the magistrate, and they had the lien reduced to $2,700, and in the settlement paperwork, at the time of closing, it shows paid to the city.
Objection,
But-
Magistrate. Both of these cases were opened under their ownership.
However, we found a document from the title company that shows there was a clerical error here in the courts, whatever. I guess they were showing more, but they corrected it. I have this paper that we just got it this morning. Should I give it to
Can
him?
you show that to the city?
No objection to this as evidence, except to point out this is from a case in 2011, and these cases are 2015 and 2016. No relation.
Because it says that there was a 26,000, almost 27,000 lien that was reduced to 10%, and you guys were charging us 3,700, but you said that it was missing $1,000 in that payment.
This is a different case. This is not the same case.
That's for 43rd Street.
Yeah,
It's the
a-
same
a
property,
diff-
but it's not the same
property, But
case.
it's a different case.
Okay.
Let
Excuse me.
him talk.
What I understand is that when I understand that we have a lien or violation, I think Ms. Monique told me that there was a reminding of the payment about this, and that's why it started again. It became again the $26,000 that it used to be. So we think that is the same case, but that's why we have that violation.
Well, I-
Then is when it started.
I can understand why you're confused. For my purposes, though, it's a different case, so it's really not relevant to this particular case.
And how come is the $26,000 that you own? Because we didn't have any violations in that house. We just, I guess, they matched together the two properties, and that's why they let us know why we own that money. I'm not sure where it comes
But
from.
what's
those
the case history
$26,000.
on the case number 7, CE 160800457?
Cited in 2016, which is 3 years after they purchased it, sent certified mail posted to property, certified mail was sent back, no signature. Let's see. Contact with a property rep in October, someone named Mario, October of 2016. I'm trying to see if that was before or after the hearing. It was after the hearing, but before the compliance date. Was not complied in time, and, oh, wait. Okay, October of 2016, spoke to Ken Best of Total Management, which is certainly one of their property managers, because that's who was mishandling the lien reduction for several years. Then after that, talked to a property manager rep named Mario. I don't know who that is. We haven't dealt with him, at least not since then.
Same office as Ken Best.
Okay, and then after that was the affidavit of noncompliance. So they had people handling it, but they never complied it. Not until July of 2017.
Okay, so my understanding is that the citation occurred while you own the property, and it sounds like your property management company didn't do a very good job.
I know.
We know.
We know. We fired him. I'm really sorry, but Mr. Posner knows how hard I work on this. When I find out this, I came every time to try to see how things are doing, and the administrator didn't do the job. It's true. And when I was in the houses, I saw that the landscaping was really bad, this and that, and I agree with all of that. It's just that we took care of everything. We spent all our money. We really worked really hard. I know it's my responsibility, because that's what they explained me, that I have to clear everything. That's why I'm here, and I really appreciate it if you can really give me a hand, because
All right, well,
this is my savings,
city,
and
I understand, sir. So the city offered to reduce the fine by 50%. What are you asking me for?
well, the truth, sir, is that the total, if it could be, but I understand that sometimes can't, but I have no more money. I spend in traveling, hotels, even food and this and that, everything. And you see, sir, I did a good job with the historical department too, because they asked me to do a few changes. I spent more than $30,000 just to fix all of that from the house, because it's an old house, it's from 1921. So we changed a few sidings. As you see the house, it looks very nice. The landscaping, we work so much. We work everything, but I spent all of this in the last 4 years because we couldn't pass it. Like my sister told you, that the administrator asked me money for one thing, another thing. We paid a lot of money to the code enforcement too, to come, the inspectors, but we couldn't pass it. And until now that I am almost bankrupt because I have to come and forth. And that's why these last 5 weeks, I work myself really, really hard. I am all hurt in my hands and everything else to be able to do what the code enforcement is asking me. So I would really appreciate it if we can pay a lot of less, because we don't have the money, sir. We are.
Make me an offer.
Bad.
What are you suggesting?
How much? I think I have like $3,000, sir.
Tell you what, I'll reduce it to 10% on each case. So on case CE 1512041, 10% is $6,250. How much time do you need, sir?
Sir, I really would like you to give me a little bit more, because I really, sir, I have to
I
come
can give you-
from
I can give you more time.
Bolivia. My ticket plane is like $1,000 every time. I paid so much
Sir,
money.
I
everything.
appreciate that. What I'm willing to do is give you an extended period of time.
A year at least.
Can you make it a year?
A year? Can you get me a year? 1 year? Please?
That's fine.
All right, 12 months.
Thank you,
CE
sir.
151204451, reducing it by 90% to 10%, which is $6,250. And CE 1602087, reducing that from 90% to $2,660 payable within 12 months. Thank you for coming in.
Thank you, sir.
Here's a copy of your orders. The instructions are on the bottom. Thank you. Okay, anyone here for 3028 Robert Road? Number 6, 4685 North Haverhill Road, CE 200103009. Number 6, 4685 North Haverhill Road.
You have to go out more time for the parking.
Okay. Number 8, 801 30th Street, CE 200200184. Number 8, 801 30th Street.
801 30th Street, right?
Go ahead.
Case ending in 184-801 30th Street, date ordered 3/4 of 20, fine started 4/5 of 20, ran for 184 days. Total $18,400, $100 a day, date of compliance 10/6 of 20. This is a new owner, only had one other case under their ownership. Mitigating circumstance they put down was that they complied it. City's asking for standard 25%.
Ma'am, can you tell me your name, please?
Yes, Samantha Sloan Johnson. My father's the owner of the house. He's right here.
All right, tell me what you're asking for and why I should grant it to you.
We would like to pay $1,200. We bought the property. That was a very long, extensive probate hearing, and we were waiting to get clear title before we took ownership, and then we complied with the property right away.
What's the time period from ownership to compliance?
Purchased in March of 20, complied October of 20.
I'm sorry, I didn't hear the first one. When did they purchase?
March of 2020, complied in October of 2020. Can you advise what it was, how much it was purchased for? I don't have that information.
You asking me?
Yes, ma'am.
Oh, we had to, there were like 6 different heirs, and it was done in like 6 different steps, so we had to pay each one different amount of money. That they lived all over the country. So it was just a long, drawn-out process, and we weren't sure if we were going to get all of the owners together for the probate. So that's why the compliance time took a little bit longer.
So the city's offering, what, 25%?
Yes, sir.
Which is, I should just bring it.
4,600.
So the city is offering 4,600.
So we wanted to pay $1,200.
Seems like a fair offer. Why isn't that a fair offer, 4,600?
Well, I mean, we've done a lot of work on the property, and we're just, and the expense of the probate and everything else. I didn't even realize that the $100 a day had accrued for that many days, really.
Magistrate, I want to help her out a little bit. He has to consider your costs, so if you can
I
tell him what you
understand.
spent on it
Yeah.
and how much it costs to get the property,
Well,
that could help you.
it's like we had kind of already paid a lot of the heirs involved before we even had clear title, and we weren't sure if we were going to be able to get all that done. And then if we didn't get that done, the property would still be sitting there. So, I mean, we paid the taxes, we paid the water, we paid everything else just to have everything clear on it.
Okay, what I'm trying to say is if you can specify what those amounts were that you paid, the magistrate has to take that into consideration as well.
For the improvements you're talking about?
For the improvements, for the purchase of the house, for paying taxes, anything you had to outlay for this property.
Oh, okay, well, the taxes were around, what, 6,000? Something like that? 4,800. The water bill was accruing this whole time, 2 years' worth. Back taxes, water. We had termite guy out there. We had, clean up the lawn. Roof repair, yep.
I'll tell you what I'll do. I'll reduce it to 2,000 payable within 90 days.
Okay, thank you.
Okay, looks like we'll go back to number 6, 4685 North Haverhill Road, CE 200103039.
I'm sorry? No, I'm Mitch. Yes. Wait until he addresses you, and then you can hand him.
Morning, Your Honor. My name is Keith Marshall. I represent the owner, Hydro West Palm LLC, 4685 North Haverhill.
I'm sorry, your last name was?
Marshall.
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 And you're an attorney, sir?
Yes.
Okay.
Case ending in 309, 4685 North Haverhill Road, date ordered 3/18 of 20, fine started 4/6 of 20, ran for 246 days, total $24,600, $100 a day. Date of compliance 12/8 of 20. This is the same owner. We're talking about a 72-unit property that appraises $8 million. The city's asking for 50% on the same owner cause violation. The only mitigating circumstance offered on their application is that they stated that they were unclear that the issue was parking on a gravel area instead of a paved area. I'd like to introduce into evidence the original notice of violation. The relevant factors were highlighted, including the part where it says, remove all vehicles being parked on gravel. It couldn't be any clearer than that. So he's asking for 50%.
All right, Mr. Marshall, the floor is yours.
Okay. The violation was unclear from the outset. It said grassy area in front of the property. This property doesn't face any streets. In other words, it's a complex where you have to enter, and all the parking is internal. Nothing faces Haverhill Road. So when we made inquiry, what the city asked us to do is pave over a 4,300 square foot area that had gravel, not asphalt. So that's what we did. We got a contractor, we bid it in a pandemic period, okay? We finally got a contractor qualified, spent $9,000 on the contract to pave it. When it went to get approved and the inspector came, he said, well, there's still some cars parking in front of the townhouses on the grassy areas. So we notified all the tenants to please not park their cars on the grass. We had this additional gravelled area paved over for that purpose, and there wasn't strict compliance. You can lead a tenant to water, but you can't make them park where you're supposed to. So I spoke to Mr. McFarland, and he said that you got to make it impossible for them to go on the grass. So what we did was we bought ballards at Home Depot, we have the invoice here, installed them along the grass area to make sure that no cars could go on that. In the interim, they had built a little doggy park, put a fenced-in doggy park. Mr. McFarland said, you should permit that, which we did. And we did this in a very timely fashion in view of all the circumstances. Hard to get a contractor. It took 45 days to get it permitted in the building department. Had to go through zoning, engineering, I think landscaping. It was at least 2 departments. So we couldn't have done anything better than that. By way of history, I wanted to tell Your Honor that when this property was bought in 2017, it was a blighted area. The heirs of the developer who had originally developed this in the unincorporated Palm Beach County as an ACLF, Aggregate Congregate Living Facility. By the time it was done in the late 1990s, it was annexed to the city as a multifamily complex. When my client bought it in 2017, there were squatters on the property. Everything was in a state of deterioration. The heirs had paid no attention to this property. Thereupon, it was acquired, got a construction and an acquisition and improvement loan, put $4 million into this property to make it a proper, livable, rateable. The taxes went up from 2017 from $80,000. It's now $230,000 3 years later, okay? So you have a great owner operating a great property, paying a lot of taxes, acting diligently, and in this 72-unit complex, the only problem the city had was there was a little gravel area that should have been paved over and make sure the tenants don't park on the grass. We did all that. We did it by paving it over. We put in the balustrades, we used to call them in the old days dead men, that they put the concrete, but these are actually posts. And more we couldn't have done, faster we couldn't have done it, and I don't think there's any reason to impose a fine on this owner.
His belief that there should be a fine notwithstanding everything is in accordance with law, so there certainly should be a fine. Regarding what they entered into evidence, only one objection on that. There's a part here that says the building department extended the time for respondent to be in full compliance with regard to all issues by December 31st, 2020, and then put in there as per Mitchell Posner, and that he complied prior to that date. I don't work for the building department, first of all, but this fine had already been running since April. I don't have any authority whatsoever to extend their compliance date December 31st. The only thing I do have the authority to extend at that point, since this was after they applied for their lien reduction, is they're given a comply date if they fail an inspection. And we regularly will extend that if they call and say we're not going to make it by that date. But we did not extend compliance date on this violation at all. He hasn't mentioned the unclear on the gravel part that much, but as I said, that's in their application, and it said straight on here. Remove all vehicles from park gravel. It couldn't be any clearer than that.
So let me see if I understand correctly. So originally the property was cited under section 94-482A for not parking on paved areas, including parking on gravel. So that they were given a certain amount of time for compliance, presumably, right?
Yes, sir. And when we got out there to check on compliance, the vehicles were moved from one unpaved area to another unpaved area, so the same violation still existed.
All right. So the fine ran from when to when?
The fine ran from 4/6 of 20 to December 8th of 20.
And what did they do on December 8th that brought the property into compliance?
It would have to be the officer, Paul McFarland, inspected and found no unpaved parking.
What, Mr. Marshall, when the property came into compliance on December 8th, what prompted the compliance? I mean, what happened?
The paving was done on June 28th of 2020. What happened was, when they came back to inspect, they found a few cars on the grass. And that's when they said to us, why don't you Paul McFarland says, put some teeth in this, make this a little more difficult for them to put on the grass, because they just seem not to be going on, all of them going onto the parking area. So then we bought the posts and put those in. We just did everything.
And that happened on December 8th? Is that
No, we did it earlier than that. And I have the invoice from, we got them on November 19th. And Mr. Roberto Benahan is here as the property manager. And when did you get them installed?
Hi, my name is Roberto Benajan. I'm the property manager for that community. I work for Penteros Properties. I was aware that we had that issue. We did everything in our power. We communicate with the tenants many times. We send property blast through text messages, so all of them receive it. We also send emails, but I communicated with any of them that were doing a violation. We have a parking addendum on our leases saying that they're not allowed to do it. And when this happened, we bought it right away. And as soon as we got it, they got installed. But it took a while for the city to come check this compliance. I know for a fact that I asked several times for them to come but this was installed basically 1 or 2 days after we received the order from Home Depot.
Okay, so the city found you in compliance once you installed these things that block people from parking on the grass, is that it?
They were out of compliance. They put in a lien reduction application in August. In September, we went and did that inspection. They still weren't complied. That was when they spoke to Officer McFarland, who suggested blocking off the grass. They did that. We did another lien reduction inspection on December 8th, and the property was in full compliance, including the case. Normally, we don't even get an application while it's still accruing. In this case, we did, and they still weren't complied.
But they were compliant by the 8th.
December 8th, yes. The last lien reduction inspection also served as a compliance inspection that they passed.
All right, and so the city offered what, 50%? And Mr. Marshall, what was your ask?
50%, sir. Oh, they asked for 0.
Right. I think we've done everything we possibly could do. We're trying to manage a property. We have tenants there. We didn't, if they would have said to us,
Sir, could you speak into the microphone?
Yeah, you have to speak into the mic.
if the focus was not on the paving, and the focus was on the, put some barriers there from the beginning, we would have done that in the beginning. We wouldn't have been here.
Well,
We would have paved it over, we would have put the barriers in there, and that was it.
Magistrate, there's no requirement for barriers. The barriers were a suggestion when they asked the officer, what can we do?
Yeah, in fairness, Mr. Marshall, the issue for the city isn't how you come into compliance, it's just that you come into compliance, that they came up with an idea that proved to be helpful, I guess, is a good mark for the city. But barriers aren't required. What's required is that vehicles can't be parked on unpaved surfaces. So I mean, making the argument that the city didn't tell you about barriers until later doesn't really persuade me of anything.
Well, I just don't know how a property owner could be any more diligent than this. If the city needs, to show something for its effort, what is the fine amount?
$24,600.
I would recommend to my client 5%, 5% of the fine.
I mean, part of the problem for me, Mr. Marshall, is that I do get a fair amount of property owners in here that and you've even seen it today, where either they weren't here, the renter did it, they thought they were doing okay, but at the end of the day, the responsibility, as you well know, falls on the property owner to stay consistent with requirements of the code. So and while I can take into account that your client clearly took efforts to try and come into compliance, and I can weigh that under the code in a fine reduction.
Your Honor,
Yeah.
we could have towed the cars. That would have been a hardship on these people, okay? So, I mean, we did what, you're trying to run a property, you're trying to keep your tenants happy, you're trying to stay rented, you're trying not to put a hardship on them, and you're balancing that interest against the interest of the city, which is, I think, it's not a safety issue, where there's any danger.
Well, gravity is one of the
Your
considerations.
Honor, it's not an aesthetic issue. The cars are not facing Haverhill Road. It's internal. So I think all circumstances, 5% would be, stretching it. But I would be willing to recommend that to my client.
City certainly disagrees that 5% would be stretching it. It would also be a slap in the face to all the private business owners if a $8 million property owner can hire an attorney and come here and get it lowered to 5% when they were at fault.
Paying $230,000 in real estate taxes, who upgraded a property from a blighted area to a nice apartment complex.
So the original fine amount was $24,600,
Yes, sir.
and the city has offered 50%, which is $12,300, if my math does correct.
Which is what it'd be for any single property owner as well.
And we're saying that 5% would be fair, more than fair.
So you're offering $1,200, roughly. All right, so let's see. Gravity of the violation, the time it took to come into compliance. Are there any prior or subsequent code violations on the property during the current owner's time of ownership?
No, sir. I don't have anything else in the history. Anything that was found during the lien production process wouldn't have been cited, so.
Any other code violations or liens for this property owner in the city?
No, there's no other properties for them in the city.
This was the owner of the property at the time it was liened.
Yes, sir.
Yes, we were the owner at the time it was liened. Your Honor, it's a single-purpose entity, it just owns its property. And it was bought to renovate and to make it a property.
Sorry, I always try and consult, the city has a very specific code when it comes
I'm
to
sorry.
to the reduction of lien, so the factors that I'm supposed to weigh. I'll tell you, so the city's offering 12.6, I'll reduce it to 7,500, payable within 60 days.
Payable how long? 30 days, did you say?
60 days,
60 days.
7,500?
yep. All right, what do we got next?
We're down to the last one if Robert Road hasn't showed up.
9 and 10, 913 6th Street, CE 09080274, and CE 12010445, and numbers 9 and 10, 913 6th Street.
Good afternoon, everyone.
Going in chronological order, oldest case first, case ending in 274-913 6th Street. Date ordered 9/23 of '09, fine started 11/23 of '09. Ran for 630 days, total $63,000, $100 a day. Date of compliance 8/15 of 2011, same owner. Case ending in 4/45, started 3/21 of 2012. Correction, ordered 3/21 of 2012, fine started 4/24 2012. Ran for 3,240 days, $32,400, $100 a day. Date of compliance 3/8 of 21. Same owner. City's asking for 50% on both. Cited 12 times under their ownership. The mitigating circumstances that they didn't need a rental license because it was homesteaded, but according to the property appraiser office with the county, dating back to before 2000, this property was not homesteaded. And our understanding is their homesteaded property now has been homesteaded, which isn't this one, has been homesteaded since prior to 2000. And one of these cases has nothing to do with the rental license, so the mitigating circumstances they put down doesn't even apply. City's asking for 50%.
My name is Amanda Preisinger. I'm his affidavit, his agent.
You're his what?
His affidavit. I'm his real estate agent.
A real
So
estate
I'm-
agent,
Yes.
okay.
We were incorrect on the homestead. He used to own both of the units, which was, what was the other address?
909.
909. He owns 913, and the 909 is the one that we got incorrect on homestead. So 909 was the one that was homesteaded. 913 was never rented. It was his immediate family was living in there, his mother, his sister, and the nieces. So he never knew he needed to get a renter's license because his family was living there. And if you look on the water bill as well, the water bill shows it's been in his name the entire time since he's lived there. He's never had it rented. So I don't know what proof does anyone have that it was rented, because it was never rented.
Magistrate, I'd like to enter into evidence a City of West Palm Beach business tax rental application certificate of use by Samuel Thompson for 913 6th Street, including the affidavit acknowledgement of landlord property owner signed by Mr. Thompson.
When was
Dated
that?
from 2012.
What was that one?
2012.
Let's see.
The city contends that if he wanted to argue that back in 2012, that would have been something to look into, but instead he applied for an application with an affidavit saying, I acknowledge there's a landlord-tenant situation.
If I may, when I
Go ahead, sir.
When I purchased the property back in 1999, my whole purpose of purchasing the property was for my mother and her brother, and my sisters and brothers, because they was getting up in age. But then again, when I purchased the property, we still had tenants on the property from the guy I got it from. So he was telling me because they was on housing, I had to renew that until their voucher ran out. So when the voucher ran out, that's when my family member moved in. And they've been there since, my uncle passed away, my mom passed away, and the whole point of it is that I know they was getting up in age, and so I was having them around the family to take care of them, because I couldn't do it because I was in law enforcement and I was a detective, so I had them doing that. So, and that's the reason why. So when they passed away, my uncle passed first, then my mother, and now the property, I'm trying to, right now, go into another profession. So I'm trying to, and because right now, being in law enforcement at that time, I created a lot of enemies. And now that I don't have control of 909, I have tenants in there which constantly are trying to violate and do things to my other property. So I just moved out and moved back to my place in Royal Palm. And so right now, I have pictures where when I go down there,
That's a part of the other violations that he's got on the property.
so when I go down there now, they done, if they go back to the other picture, the one in the front, they completely moved the fence because they doing, that fence right there's completely removed because they got drug going in and out of 909. I done called court enforcement, I done called City of West Palm Beach, I done called the sheriff department. I mean, you can go down and you can sit and you can see the traffic all day long. So right now what I'm trying to do is, because I'm not gonna say I'm in fear of my life, but I don't want to be in that type of position, don't know what I'm gonna do, try to defend myself. So, and again, these violations are something that, number one, I don't need, like I say, the permit that I got the first time, rental permit, is because I already had tenants in there when I purchased from the new owner. That's not something I redid because my family member moved in. And when I lost 909 in a divorce, my ex went and moved to Virginia and took the kids. So then I moved out in Belgrade when I was a detective because it was easy for me to be involved in the community, being out there instead of traveling back and forth.
All right, well, hold on one second, because I got to be honest, I'm pretty confused about what's going on here. So this business tax rental application from April 5th, 2012, when was he cited for landlord-tenant for the absence of a rental license?
Just want to make sure I'm looking at the right case of the two. Okay. March 21st, 2012.
So he's cited in March for not having a rental license, and then he filed this application for a business tax.
He submitted that. He never completed the process, never called for inspections. It was never issued.
Okay.
Because I was told I didn't need one because my family was living there.
But I thought you just said that there was somebody living in there, which is why you applied for this.
Right, but he's not showing you that one. When I purchased it in 1999 from the previous owner, he was telling me I need to.
Oh, so then why did you apply for this?
Because that's what he was told to do.
That's what I was told to do.
We applied because they were told to do. We applied as well. If you look on there, you'll be able to see when we found out he had this renter's license violation, that we just found this out in December of 2020. We just found that out. So if you look on it too, we just applied for a renter's license again because we thought that's what we had to do until we finally spoke to Mitch and the code enforcement officer, Phil Cartwright, and he says, well, why do I'm going to fail inspection to get the renter's license. We're going to fail inspection because there's no water. I'm like, we haven't had water turned on in over 8 years. And then we had to pay, that's another part of the issue is we just had to pay last week $16,000 check to pay the water bill from 10 years ago that no one's been living in there. That's why it's been occurring. The water bill was occurring to even get on this docket. We had to pay a $16,000 bill and no one's been living in there for the past 10 years.
How did you have a $16,000 water bill?
And that's another issue, is because back in 2000, would you know when exactly, what year? But when he was renovating, remodeling Unit 2 and 3, which his mother and his niece were in there, he was remodeling 2 and 3, and they had the utilities department replace the water meter, and he was out of town at the time when Unit 2 and 3 was being remodeled, so the water was off at that time. When the city of West Palm replaced that water meter, the guy, who you guys third-partied it out to, they had turned on the water when he was remodeling, so it flooded Unit 2 and 3 for a couple of days. They admitted fault for it, and they ended up paying for having to get them into a hotel for a couple of days. That's how bad it was flooded, so that water bill racked up for a couple of days, however long that the water was turned on for, and then it flooded the entire units. So they ended up having, that's why the water bill was over $16,000, because he couldn't get that resolved, and the only way for us to get on the lien reduction was to pay that in full. We couldn't even come here to negotiate that. So he just used all of his savings to pay the water bill just to even come here today to get on this docket. It's a, yeah.
I have no idea what to
Magistrate, I'm going to start with the devil is in the details. I have to assume that a police detective would certainly be aware of that. We have a legally notarized lien reduction application stating this should be reduced because it's a homesteaded property and it's never been rented. Both of those statements have now been amended here at the hearing, as well as a large number of reasons as to why this should be reduced that never made it into the application. If we're going to consider those factors, I wish to pull this and present it another day. This should have been in the application.
I think you have a lot of things here that are unresolved. And I got to be honest, I'm not really sure what to do with this. There's a lot of stuff going on here. I mean, if I were to rule right now, I probably wouldn't. Just because I don't know how to account for some of the things that you're telling me. My suggestion would be for you to have a meeting with him and see if you can work this out.
That's what I've been trying to do, and I have emails and proof of documentation of that since December. I've been emailing Mitch. I've been also
in fairness to Mr. Posner, he gets quite a volume of stuff related to fine reduction.
She has emailed a number of times, but the only real authority I have is to present a lien reduction. So I've tried to help them get through to this.
But this is
process.
I mean, I can give you an option. I can make a ruling here, or I could give you time to talk to Mr. Posner and maybe come to an agreement about what would be appropriate in this case, because it sounds like you have some facts that I guess he hasn't had a chance to digest either. And maybe that would be a little more helpful to the ultimate resolution of this. But I leave it up to you. I can tell you this: if you're not able to resolve it with the city, you can come back next month, and then I'll resolve it for you. But I think you might get a better outcome that way.
I want to make 3 points for the record. One, it's actually Posner, please.
I'm sorry.
Two, I misspoke on
the city attorney
case.
will back me up that there is a very famous judge named Posner.
There's a famous singer named Posner. Okay, case ending in 445, I did misspeak, and the ask should have been 20%, not 50%. That's a six-figure lien. There's no way we're asking for 50% on that. I just realized that mistake. And for anything else, I mean, we can discuss other factors, but I didn't know of them beforehand. So it's up to you how much of a hurry you're in to get a lien reduction done as to whether or not you want to render a decision based on what's here, or pull it and try to see if there's anything else you can provide to show everything you're saying.
Well, I just want to say this, Mr. Minch, I apologize, but at the time that the application was done, it was done with me being on the phone with someone else that was trying to help me out. So I didn't personally do it myself. So whatever's in there, I don't know what was in there, and I apologize. But the point of the matter is that, you know, right now I'm just trying to move on. I understand what you got through saying, sir. So, and I don't know what's going to be best, because I do have other things that I'm trying to do. Like I said, I'm trying to move on,
Okay.
you know, because I spend a lot of money, and then again, my whole concern is, like I said before, I am overcautious that when I go back down to my property, I might end up having to defend myself because, again, I'm dealing with criminals.
I can't speak to that. I will say that you've thrown a lot of stuff at me, so it's kind of hard for me to sort of assess that. If something has to be done today, I can make a ruling today. I'm just suggesting that look, I'm here every month. Actually, the city meets twice a month. I'm only here for one of them. We can bring it back and put it on the agenda after you've had a time for the city to sort of go through some of the things because I rely on the city to provide me with factual information about cases, right? And so one of the things that was pretty clear here is that he wasn't aware of some of the factors that you were bringing up. And that's why it's useful sometimes to put those in the affidavit, because then the city can check them and come back and say, hey, we checked this and they're right that, this happened or this didn't happen. And I rely on them to provide me with honest and accurate information. In this particular case, I don't know how to weigh some of the stuff that you're telling me, because the timeframes are, as you can tell, I'm sort of jumping between timeframes. I'm looking at an affidavit that says that there was a tenant, you're telling me there wasn't. So for me, it's kind of hard to make a fair assessment of what you're asking me for. Now, if there's an immediate thing, if you want me to make a ruling, I'll make a ruling, relatively, on what I can understand from this. I'm just giving you the opportunity, if you'd like, to speak to the city to see if you can resolve some of the underlying facts.
If I can ask, is this under contract?
It says, and we're,
So that's why, it's your decision as to whether or not he makes a ruling. My understanding is it's under contract for $350,000.
correct.
Okay, so,
And-
again, he's left it in your hands. Do you want him to decide today, or do you want to? Either way, we're going to have to come back here. The only thing that could change is the facts presented to the magistrate as to what the amount of the lien is, based on what you could provide to back up what you've been saying.
Okay.
So either way, a decision will have to be made by a magistrate before the lien can be removed.
Well, so
So
since,
it's up to you guys to decide, do you want to do that today, or take longer and come back
well,
another
with the
day?
renter's violation that we're referring to, I guess what we're asking is, what proof do you have that it was rented out, I guess, from that time?
The burden of proof is not on the city in this case, right? A lien reduction, the facts of the case weren't appealed, so the lien was valid at the time it was given. So at this point, essentially what you're making an argument under the code is that there were factors that I should take into account in trying to decide whether or not the lien should be reduced. It's not, we don't relitigate the underlying question anymore. That was already litigated.
Okay, because I guess that's what, I guess we're trying to understand though, is since that's the violation that he has, how did he know that he had the renter's license violation?
Yeah, that's the question you argue at the time that it's brought, right? So they come, they say, hey, you're doing this, you say I'm not, and then you argue, and then the magistrate back then, whenever it was done, makes a decision based upon those facts. But that's already happened. So that process is done. So we're in a different process.
Also, I don't know if you're referring to, how do you know there's a violation? He would have been sent a notice of violation in the beginning. I don't know if that's what you're referring to.
Yeah, because he never knew about the violation that we even had. That's why we had no idea it was $324,000 until December when we're trying to sell the property. That's the only reason how we found out was from the title company.
Well, the notice of violation would have been at the beginning of the case, and it would have gone to the address that he had registered with the property appraiser's office.
Which is, what address would that be? Because his address on there is confidential.
Well,
It's a P.O. box that's listed, probably for that reason. I don't know what his reason would be to have his notification on the Papa sheet be a P.O. box, but that's where it was sent to. It's on the Papa sheet in front of you, sir. Yes, I'm aware his home address is confidential. That has nothing to do with the noticing that we sent.
And typically, the city will also post the property.
Okay.
Thank you, sir.
So then what do you want to do? Because you have to pay Royal Palm.
Yeah, I'm working on that now.
I think the next hearing's June 2nd, right?
Next hearing is when? Thank you,
It should
ma'am.
be June.
I believe so, yes.
June 2nd?
June 2nd?
Would we be able to get on that? The reason why we're trying to figure out, because we've already been under contract since December, and the people who are trying to buy it can back out in the end of June, and that's.
I can set it for June 7th, but you'll get the other magistrate, but, I mean, he's as reasonable as I am.
Yeah, June 2nd.
June 2nd? I won't be in town.
You're out of town.
Yeah.
June 2nd, it's a different magistrate.
What's the other one in June? Because he's out of town.
2 weeks after that, the 16th.
2 weeks after that, the 16th, so June 16th.
What about the contract?
Pay Royal Palm by when?
If we pull this today at your request, it's not a problem getting onto another agenda. You've already qualified for hearing, so we don't start that process over or anything. So then it's just up to what you
We'll
want to
just
present.
set it for the meeting.
What'd you say, Your Honor?
We can just set it for the meeting, whichever one you'd like.
We're trying to figure out, because he has a deadline to pay
Well,
another.
if you know you want to reschedule, we can just say reschedule, then you can talk to.
So then do you want to
Yeah.
just reschedule then?
Thank you, ma'am.
We'll reschedule.
Okay.
For which one? Because you can set it right now, right?
They can
We can
pick.
think about it and let you know.
Okay, we can do it that way.
All right, anything else?
Not that
No
I
one
have,
else in
sir.
here, so if there's, is that it? Is that it? We don't have any other cases, right?
Well, number 2 and 3 other matters, I guess they're rescheduled.
Is that for Robert Road? I don't know, they didn't show up, we'll have to find out why. According to city code, they don't show up, they gotta wait a certain amount of time before they even can.
Right. So, that was number 2, 3028 Robert Road, CE 060100463, and number 3, CE 060700723, both no-shows.
That was the Melinda Mitchell?
Yes.
All right, well, I mean, I guess they'll have to resubmit, I guess. All right, seeing no further business before us, this meeting is hereby adjourned.